Welcome to Oil and Gas Law with Energy Law Prof. Today we'll talk about using the pooling clause to maintain the lease through a constructive production clause. So as a reminder, when we talk about pooling, we're talking about bringing together neighboring plots of land for a single well. That's by contrast with unitization, which is where we bring together lots of wells, maybe dozens of wells, maybe 100 landowners who all operate a single reservoir with a single plan for producing it most efficiently. So pooling is that more simple process where we simply bring together a few landowners to share the oil and gas from a single well. A typical pooling clause gives the oil and gas company the ability to pool neighboring plots of land. And that can be very useful because often the same oil and gas company has leases on neighboring pieces of land. So they're effectively negotiating with themselves to pool that land and operate it together. And even if they don't have the lease on the neighboring land, they can negotiate with the oil and gas company that does have the lease on the neighboring land. So, as a simple example, imagine that you have two 20-acre properties next to each other and you need 40 acres to drill. You could pool those whole 40 acres together and then you could put a single well on the property. The oil and gas produced from that well would be shared between the two properties. Here's what a typical pooling clause reads like. The lessee, the oil and gas company, is hereby given the right and power to voluntarily pool or combine the acreage covered by this lease with other land, lease, or leases. Operations for drilling on or production of oil or gas from any part of the pooled unit shall be considered as operations for drilling on or production of oil or gas from the land covered by this lease. For the purpose of computing the royalties, there shall be allocated to the land covered by this lease and included in said unit a pro rata portion of the oil and gas produced from the pooled unit. Such allocation shall be on an acreage basis. So to return to that simple example where we have two 20-acre properties pooled together in a 40-acre unit, you have the well on one of those properties, but the oil and gas gets shared with both properties. So imagine that each of those 20-acre landholders have a lease that entitles them to 1/8 of the production from their land. If they only have half of the production from that pooled 40 acres, then they're going to get 1/2 of that 1/8. They'll get 1/16. And so it sort of makes sense that as long as that landowner is receiving a royalty from oil and gas that is attributed to their land, that the lease should continue even if there's not literally an oil and gas well on their property. Because although there's not literally an oil and gas well on their property, there is one on their neighbor's property, and that oil and gas is being shared with them. So the pooling clause, in some sense, makes a lot of sense. You might even think about it as a great thing for the landowner because it gives them the opportunity that there could be oil and gas that's shared with them, but they don't even have to have a well on their property. And we can see that sometimes those wells on their property annoy those landholders. So what's the problem with the pooling clause? Well, it turns out there's a lot of problems. In fact, if you go out and read some of the conventional wisdom from like landowners, rights groups on the pooling clause, sometimes they'll say you should just strike that out. Why would landowners not like this pooling clause? Well, we'll see that there are ways for the oil and gas companies to use that clause to benefit the oil and gas company's interest that may harm the landowner. Now, I think that suggestion that you just strike out the pooling clause is typically a very bad one because the pooling clause has a lot of necessary uses, can be very efficient. Some properties can't be developed without a pooling clause. But over the course of this lesson, you'll see why sometimes landowners are wary of oil and gas companies' use of the pooling clause. So, what are some common pooling issues? Well, one is that if the lease has limits that are on the pooling clause that say it can only be used in certain circumstances, then the oil and gas company is going to have to strictly comply with those limits. And we'll talk about some of those limits moving forward. But even if the lease doesn't have any special limits on the oil and gas company's right to pool the property, the oil and gas company still has to pool in good faith. And we'll see what that means. We'll see examples of bad faith and how difficult it can be to draw the line between a good faith use of pooling and a bad faith use of pooling. Some other questions that commonly arise, may the lessee, the oil and gas company, pool more than once? So, what if they pool a unit for a well and then turns out there's no oil and gas there, they dissolve the unit, and then they want to pool again with a different landowner? Would that be allowed? One issue that arises sometimes under the limits of the lease is that the lease may say that you're only allowed to pool if that's required or prescribed by the Oil and Gas Conservation Agency, like the Texas Railroad Commission or the Oklahoma Corporation Commission. In that case, if the Texas Railroad Commission is requiring 40 acres for a lease, then you can go ahead and bring together two 20-acre units for a 40-acre pooled unit to allow you to drill. But what if you think, well, actually in this case, it'd be more efficient to just have one well for 60 acres. Okay, if that's not required by the Railroad Commission, you might not be able to do it under a lease that says you're only allowed to pool if it's required by the Oil and Gas Conservation Commission. On the other hand, if the lease says that you can pool whenever it's allowed by the Oil and Gas Conservation Commission, then maybe you can pool a larger unit of land together, and we'll see an example of that later in this lesson. Another question that sometimes arises: can the lessee pool after they already found an oil and gas well on one of these neighbors' lands and they are already started to produce oil and gas? You remember that happened in that Carson Mineral Interest Pooling Act case that we discussed earlier in the course. And the oil and gas company said, we better get these neighbors sharing in this well. Now, sometimes that might be a problem if the lease says that you can only pool to secure development. In other words, to make a well possible. And you can imagine that landowner who already has an oil and gas well on their property might say, well, look, clearly pooling isn't necessarily in this case because you already developed my land. You already put an oil and gas well on it, so it wasn't necessary to secure development. And so that's another lease limit that you might want to look at to see if it's in your pooling clause. Final question that comes up is, can you pool and set the date of pooling at a prior date? So again, imagine that there's already a well producing oil and gas, but then you realize, I should have been sharing this with these other neighbors that also have the lease on their property. Can I say, you know what? We're going to pool this property and we should redistribute that oil that we already produced from the well? The answer to that is typically no, but you can see that that might be something that oil and gas companies would like to do. All right, let's assume that you have complied with the lease terms. We'll see that the oil and gas company, because of their ability to choose how to pool, can manipulate the pooling decisions in ways to benefit their own interests. And so let's explore this issue of what counts as good faith pooling. So let's imagine we have our friendly oil and gas company, Acme Oil and Gas Company, and they have the leases on 6 neighboring pieces of land. Each of these properties is 20 acres, and let's say it takes 40 acres for a well. Now, how should Acme pool this land together? Let me give you another fact about Acme, which is that Acme, as it turns out, it maybe leased more properties than it has the ability to drill right now. And these leases are about to end because the primary term is coming to an end, and Acme really doesn't have the ability to drill too many wells. It has a lot of other properties that it would like to drill and that are also near the end of their primary term. Doesn't want those to end either. So it's trying to keep as much land as it can with a minimum of drilling. Okay, the first thing that might occur to you is, okay, let's just pool all of these in a north-south manner, and so then we only need 3 wells to keep all the properties. But I wonder if any of you can think of a way that you might be able to pool this to keep all the properties with even fewer wells. Think about that for a second. Okay, so here is one way you might be able to do it. What if you just pooled the middle of these so that you actually got all of this property in the middle, but you got just a little bit of all these properties on the side. Remember that under a typical oil and gas lease, if there is any production of oil and gas in paying quantities on any part of the lease, that lease will last as long as that production in paying quantities continues. And so even though only a small portion of some of these properties is being produced, that entire lease will remain with the oil and gas company. So by drilling one single well, that oil and gas company on one 40-acre unit is able to keep these entire 120 acres of 6 leases. So you might think, is that really good faith? They could have done pooling that corresponded with the lease lines, and instead they chose this kind of unusual shape. Is that in good faith? Note that, remember, under pooling, how much is shared with each landowner is dependent on how much acreage is in that pooled unit. So these landowners on the side that just have a small corner of their property producing oil are only going to receive a tiny fraction of the oil and gas from that well, even if it is a profitable well producing in paying quantities. And so this, to most of these landowners, is going to look like bad faith. We'll see that exactly these kind of questions come up regularly in oil and gas disputes, but let's leave this aside for a moment and let's say that Acme thought, we can't get away with this. We're going to have to follow the regular lease lines. What we can see is there still may be room for the oil and gas company to make pooling decisions in a way that benefits its interest and not the landowner's interest. So let's change the situation slightly. Let's change it in a couple ways. One, let's imagine that Acme has just 4 leases, but on the other 2 properties, they actually own the land outright. So the big difference there is that means they don't owe a landowner royalty. So if they owe a 1/8 royalty on those other 4 properties, that means they only get to keep 7/8 of the oil, but they get to keep 8/8 of the oil, all of the oil, on the 2 properties that they own. So Acme is going to really like it if the oil is produced from a pooled unit, including its 2 properties, because it gets to keep all of that. But because it is the lessee, the oil and gas company, on the 4 other properties, it gets to decide how all of this is pooled, because it can negotiate with itself on how to pool these properties. Now, how should it pool these properties together? Well, you might say that it could do what we looked at before about the maybe sort of natural thing and have 3 north-south units that just all look basically identical. Now, from Acme's perspective, it's not great for the middle one because that one doesn't have oil under the property. Because what's also different about this circumstance is that Acme knows or has a good idea that the oil is really located in 2 sort of small reservoirs, one on X and Y's land and one just on V's land. And so if Acme's middle property is pooled with W, they're going to end up sharing nothing because it's just going to be a dry well on that property. So what if Acme says, you know what I'd rather do? Let's do east-west pooling for X and W and Y and Acme's property, and then let's do a north-south one over here, and that's going to be great because all of my 2 properties are going to have a share of production from these reservoirs. Okay, well, who's going to be unhappy about that? Probably X and Y, because X and Y are going to say, look, the oil is on our property. Why should I share with these neighbors that don't actually have any oil and gas on their property? So the sensible way is to go with that north-south pooling. So you could imagine in that circumstance, X and Y saying, you know what, Acme's plan of ensuring that the properties it owns outright get a share of every reservoir, that is not good faith pooling because they're putting their interests above the interests of the lessor, the landowner. Okay, so let's say that Acme says, okay, we can't do that. Let's go back to north-south pooling. It's not great for us in this middle property where we share nothing with W, but at least we get a share of V's oil. Now, who might say it's not good faith in that circumstance? Probably W, because W is going to say, look, I don't want to share nothing. Why don't we just have both W and V sharing, and then Acme, you can share nothing with yourself on this property. So one question you might ask is that what Acme is required to do? Basically ensuring that all of its lessors, landowners, get the maximum possible share of oil and gas, and then putting its own interest below those of all the landowners. Okay. What I'm here to tell you is there's no clear answers on this. And that's because good faith isn't a very clear standard. So there are some other standards in the law that would require Acme to always put the interests of the landowner or the lessor above its own interest. That would be like a fiduciary duty. You may remember, if you've taken business associations, the case Meinhard v. Salmon, where they say that fiduciary duty is a punctilio of and honored the most sensitive. That kind of fiduciary duty is not what good faith is. It's something less than that fiduciary duties. The courts have said good faith isn't quite a fiduciary duty. But then the question is, okay, well, we've seen a lot of different possibilities for pooling here, from ones that would totally serve Acme's interest at the expense of the landowners to ones that would totally serve the landowner's interest at the expense of Acme. Where along that spectrum is Acme required to pick to satisfy good faith? And the possibly unsatisfying answer is we don't know exactly. Let me give you an example of a case where there was really a lot of evidence of bad faith. This is Amico Production versus Underwood. It's a case from Texas, 1977, page 286 in your book. In this case, the lessee oil and gas company formed a 688-acre drilling unit that covered 8 different leases. That those leases combined covered 250 acres. So in other words, it's kind of like that first bad faith example I gave you, where you're keeping a bunch of leases together by taking just a small portion of each of the leases, and we'll look at a map showing that in just 1 second. So other things that were a little sketchy about this, there's some clearly non-productive property included in the unit. So like, why are you bothering pooling in this land if it doesn't have oil and gas on it? And then there is some oil and gas productive property that's excluded from the unit. So it seems unfair that they're not receiving an allocation of production. Finally, as we'll see, there's evidence that the purpose of this unit was to extend the leases and that there wasn't plans to drill additional wells. This was basically to try to keep as many leases as possible with a single well. Here's some of the evidence. So you can see this is a letter. It's from May 20th, 1975, just 5 days before the leases are going to end. And it says some things that you really aren't going to want to see in a lawsuit. One, the unit wasn't essential to drilling. There was actually already a well that was drilled and being completed. Two, the majority of leases were going to expire in 5 days, on May 25th. And three, the purpose that it explains for the necessity of pooling a unit together is to hold the majority of your leases. So this seems to be a case where there's a lot of example of potential bad faith, and we'll see more of it here when we look at the map. So let's look at this map for a second. What I want you to notice is that first, this is a very weirdly shaped unit. You can see that it doesn't follow these sort of normal section boundaries. Instead, it basically zigzags around, catching little parts of neighboring properties to ensure that it keeps those leases. And it actually excludes parts of the Section 3, which it could have just been based around Section 3. So it seems relatively clearly designed to keep all those extra leases. Now, as we said, the unit well had already been drilled. Section 3 was big enough to accommodate a full unit. So there was no need to extend into these neighboring properties that just allowed Amoco to keep more leases. Amoco doesn't have any plans to drill more wells. It's excluding some productive property like these corners of Section 3 from the unit, but at the same time, non-productive property from these neighboring sections are included. So everything about this seems to be designed to simply extend as many leases as possible so a single well can keep everything. And that's the kind of shenanigans that you're looking out for when you're trying to see if there's bad faith in the use of pooling. Okay, what are some other kind of lease limitations that there can be on pooling? Clearly, oil and gas companies have a lot of ability to use this to benefit their own interests over landowners. And you can try to rely on good faith, but if you have to go to court to try and convince judge and jury that this is bad faith pooling, you're really not in a great relationship with your oil and gas company. So are there any ways that you can limit these shenanigans up front? And the short answer is yes, there are some ways. Here are some of the provisions you could use. First is an anti-dilution provision. And what that basically does is says, okay, if you're going to pool in just a portion of my lease, you better pool the rest of my lease into another productive well. There are Pugh clauses, which basically say if you're just going to pool a little piece of my lease, give me the rest back. And so if the rest of the lease expires, then I can go and get a new bonus, find a new oil and gas company to drill there. Retained acreage clause is kind of a more sophisticated, elegant version of a Pugh clause because it applies not just to pooling, but also to just drilling on a small part of your land. So retained acreage clauses would be particularly important if you had a really big property. So imagine that you had a 5,000 acre lease. So you have a huge property and the oil and gas company that's developing it only drills one tiny little 40 acre unit on your property. And so this whole rest of the property has no production on it. In that case, you wouldn't be protected by a Pugh clause because that only protects you if a small part of your property is pooled into a unit. And so you need a retained acreage clause that says, for whatever reason, if you just pool the small part of my property into a unit, or if you only drill the small part of my property, you don't get to keep the full property. Whatever you didn't develop goes back to me, is retained by me. Okay, so let's talk about these provisions a little bit more in depth. First, let's think about what kind of provision is this? Is this an anti-dilution measure? Is this a Pugh clause? Is this a retained acreage clause? The lessee shall not be granted the right to pool any of the leased premises for the drilling of or production from any well located on the leased premises, which is anticipated to be classified or is ultimately classified as a gas well by the governmental entity having jurisdiction over the same, unless all of the leased premises is located either within the pooled unit for such well or within a unit for another gas well producing in commercially paying quantities from the same formation. So what kind of provision is that based on my descriptions of those? Well, it's an anti-dilution provision. So imagine that you have your property and just a little bit of it is pooled into a wider property and you're sharing in the production from that. Well, because you share on an acreage basis, you only get credit for your acreage that's in that pooled unit. And you might say, well, that's not enough, and I'm concerned about that. So the solution that this clause proposes to that circumstances says, okay, well, sure, you can pool in just a portion of my property, but then you need to pool the rest of my property into another productive well so that the whole of my property is being produced. So that's an anti-dilution clause. Now, one problem with the anti-dilution clause is sometimes it may be the case that most of your property gets pooled in to a productive well, but really there's parts of your property that it's not possible to pool in. And you've basically completely stopped the ability of the oil and gas company to pool in even the bulk of your property in with somebody else. And there might be circumstances where that's really harmful to your ability to develop your lease at all, or the oil and gas company won't agree to it. So a somewhat more elegant solution is a Pugh Clause. Pugh Clause says, you know what? If you pool in just a portion of my unit, that's fine. Just give me the rest of the lease back. So here's an example. Pugh Clause: drilling operations on or production from a pooled unit or units established under the pooling clause shall maintain the lease in force only as to land included in such unit or units. The lease may be maintained in force as the remainder of the land in any manner herein provided for, provided that it be by rental payment. Rentals should be payable only on the number of acres not included in such unit. So, in other words, if you have just, let's say, half of your property is included into a pooled unit, that's fine. You're going to get production on that half, but the rest of the half goes back to the landowner if there's no drilling on it, if it's not pooled into another unit. So that's what a Pugh Clause does. Now, in your book, you have a description of a case. You don't have the full case. Bibler Brothers versus Tojak. That's from Arkansas, 1984. In that case, there was a Pugh Clause, and here's what it said. In the event that only a part of the lands embraced by this lease are included in a unit created hereunder, then the remaining portion of the lands embraced by this lease shall be subject to the delay rental payments as provided in paragraph 4. Okay, great. So it's a Pugh Clause. The problem is here, the lease wasn't pooled through negotiations by the oil and gas company. It was compulsorily pooled by the state. So in other words, Arkansas says, we're pooling this unit. Now, how is that a problem under the specific terms of this Pugh Clause? Well, the basic problem is that this only applies to sever the lease for a unit created hereunder. What does hereunder mean? It means under the terms of the lease pooling clause. And that gives the oil and gas company the power to pool the land. This wasn't pooled under the lease. It was pooled by Arkansas, and so the court here says, you know what, Pugh Clause is not triggered, and so this production from just a portion of the lease keeps the whole lease regardless of the Pugh Clause. Okay, so the Pugh Clause is a little bit better than that non-dilution clause, but a retained acreage clause is really better than both. Because remember, that retained acreage clause, that's really good when you have a really big property, and if you're not only worried about somebody just pooling a portion of your lease, you're worried about the oil and gas company, even without any pooling, just doing a single well or maybe 2 wells on your giant property, and those being able to keep your whole lease forever. So here is what a retained acreage clause says. Upon pooling a part of the lease premises or completion of a producing well, the lease shall be severed and shall be considered as separate and distinct leases on the pooled acreage or on the tract comprising the drilling unit for such well and on the rest of the lease premises. The term of each resulting lease caused by any such severance and all the rights and obligations of lessee under each such lease shall apply separately to the acreage attributable to the particular lease for the foregoing severance. So in other words, if you have that giant property, and let's say that the oil and gas company, pools in this corner to one property, it actually drills a well here, it drills a well here. The whole rest of the property, everything that's not held in that way, will be severed into a new lease, and if the oil and gas company doesn't drill, that lease will expire, and that landowner can then lease it to somebody else, get a new bonus, etc. So the retained acreage clause is a more sophisticated version of the Pugh Clause. It protects you not just from pooling just a small part of your land, but also from only producing a small part of your land, and says oil and gas company only gets to keep what it's producing. So that's the retained acreage clause. Now, when we're thinking about either a Pugh Clause or a retained acreage clause, it's also important to think about whether we want a simple clause that only applies to vertically slicing the land. So basically saying, okay, you keep those 20 acres, we'll keep these 20 acres. or if you want it to horizontally slice the land as well and say basically, sure, you can keep the shallow surface, the shallow deposits of oil that you're producing, but you don't get to keep the deeper amounts that you didn't produce. Okay, so the simple version of a Pugh clause or retained acreage clause is a vertical clause. So as we're going to talk about, especially with fracking, look at all these different layers underneath the earth. Each of these layers may have oil in it. So you may have conventional deposits, and then each layer of sediment underneath the earth may have oil and gas in it that you want to produce. So you can think about all that oil and gas underneath the earth as basically a layer cake with lots of different layers that all may have oil in it that you'd all like to produce. Now the simple Pugh or retained acreage clause cuts that layer cake in the normal way. So it cuts it vertically, right? And it says, look, you get to keep where you've produced, but the rest over here, that goes back to me. Okay, so that's what a typical vertical clause, like cutting cake, typical way to cut it is vertically. Now, the more sophisticated way, this is described on page 300 in your book, is to cut it horizontally as well. Now, I say that's more sophisticated. If we were talking about cake, you know, somebody, if you're at a birthday party and somebody cuts a layer cake horizontally, you know, maybe you should run out of the room. I don't know. It's probably a bad sign. It's certainly a weird thing to do. But it can make a lot of sense when you're talking about oil and gas development, because sometimes you might say, look, if you're only producing these shallow layers here, give me everything that's deeper than that. Because just by the same principle that I wouldn't want you producing just a tiny corner of my ranch, if I have 4, 5, 6 layers of oil underneath my ranch and you're only producing the shallowest one, give me those lower 4 or 5 back. And so in addition to cutting things in the normal way, vertically, you could cut them horizontally. That would give the landowner more protection. And so for sophisticated landowners, we're seeing more often the use of both a vertical, the normal way, and a horizontal Pugh clause or retained acreage clause that says, I get to keep effectively everything that you're not producing. So if I have that vertical and horizontal retained acreage clause, effectively what that says is the oil and gas company only gets to keep the acreage back and forth and the depths that they are actually producing, because we are going to sever this lease both vertically to give me certain acreage back and horizontally to give me certain depths back. And that's why that can be a very powerful tool in ensuring that the oil and gas company goes ahead and produces all the oil and gas on your property from each reservoir, or else gives you that lease back.